Not only he's a legal counsel for IABC, he's also one of the Indonesian Consul General in Los Angeles Legal Counsel. Ladies and gentlemen, please give a warm welcome to our speaker, Mr. Rizyan.
I can't help but notice the nice graphic from Norman, PowerPoint, and but more importantly, the very interesting data that's from the PowerPoint. Mine is unfortunately just words, so I hope you guys don't fall asleep on me. So, okay, so well, before I begin, I'd like to thank the Consul General for Indonesia, Honorable Hadi Martono, who is kind enough and who had taken some time to actually be here tonight, to be here at the Business Mixer. I'm extremely honored by him being over here. So, good evening, ladies and gentlemen. Thank you for coming tonight. So my presentation is about legal issues that affects small business. I was actually curious to find out what the definition of small business is. And so I went to the SBA website, and here's what I found out. So it's defined as a small business concern that is independently owned and operated. It's organized for profit, and it's not dominant in its field. Now, if you think that small business is your mom and pop store, I can tell you that in the manufacturing sector, it includes companies that has employees up to 1,500. That's 1,500. And in the service industry, it's companies that has revenues of about 21 million. So I think for most of us here, I think we fit into the definition of small business. And that's why I want to talk to you guys a little bit about that. So, can we go to the next slide? So, the first issue that I want to talk about is whether or not your company is set up as a sole proprietorship or an entity. And for my discussion, what I meant by entity is actually a corporation or LLC. But when I mention corporation, I would also include LLC for purposes of tonight's presentation. Now, let's go with the first one, the sole proprietorship. This is the simplest and most common form of organizing a business. It's basically run by an individual or husband and wife. There's no distinction between you and the business. So you get all the profit, but you're also responsible for all the debts, losses, and liabilities. Now, I want to talk a little bit about the liabilities because there is personal liability when it comes to sole proprietorship. That's the biggest problem in having this kind of structure. And what does that mean? That means that your personal savings, your house, your cars, they are all exposed if you are in trouble financially. So, on the other hand, for entity, the biggest advantage is actually limited liability, which also means that your personal assets are protected. I'll go into that a little bit on limited liability in my next slide, but the second advantage is of having an entity structure is that it's easier to obtain insurance. It's also a better perception to your customer. So it's always nice to have the word corp at the end of your business name. It sounds more like an organized company. It's also easier to raise money because you can sell your shares, your stocks of the company, and it's also easier to get loans. So on my next slide, forming a corporation has its own responsibilities. Why? Well, because you want to make sure that the corporate veil is not pierced. You don't want your creditors to go after your personal assets. So you have to maintain this veil. Now, what I mean by veil is more or less like a wall between you and the business, okay? So whenever you set up a corporation, you create this wall between you and the business to prevent your creditors from coming after you personally. So, but that still would stop people like me from coming after you personally. I'll do my best if I represent a client. For example, okay, I represent a supplier, and he had supplied products worth $500,000 to this company. As usual, the company is run by one shareholder or two shareholders. It's undercapitalized. The business basically has no money, but the owner has plenty of assets. So what do you think I'm going to do? I'm going to tell bad news to my client and tell him, you out of luck? No way. I'm going to come up to you and try to pierce that wall. That's what I'm going to do. So, now, how do we maintain this separation? How do we maintain this wall so that it's not broken, so you can stop people like me from coming after you personally and getting your personal assets? So, you want to make sure that the formation papers are done properly, and that includes your articles of incorporation and your bylaws. Hopefully they're done properly, okay? You should issue stock certificates to all the shareholders. Make sure you fill out stock ledgers, okay? And the next one is something that's very common. Common mistake, when you mix personal with business finances. A lot of people do that. Imagine, okay? Today is the last day to pay for your mortgage. Okay? You forgot to bring your personal checkbook. You in your office, okay? To prevent penalties. When you're late, what do? You pay by e-check. But you forgot your personal checkbook at home. You're the only shareholder. What's the harm? Use the e-check with your personal bank account. Pay for it. And after a while, it gets easier. You pay your utility bills with your business checking account. That's when you mix two together. That's a problem. Okay? So you want to keep them separate. Keep good accounting records. That means fill out your ledgers, do your bank reconciliation. Have your annual meetings. Prepare your corporate minutes. Okay? And make sure that when you sign documents, when you sign applications for licenses, make sure you sign it on behalf of the corporation and not on behalf of yourself, okay? So when you sign it, make sure you put down CEO of whatever your name of the company is, okay? So, a couple of side notes that I think it's quite important. So what happens when you have two businesses? Should you have just one corporation for these two businesses, or should you keep it separate? My suggestion, keep it separate. One corporation for one business. Let me give you an example. A few years ago, I'm sure there's got to be some real estate agents over here. A few years ago, real estate is great. People are making money off real estate. You make lots of money. So that's your real estate business. Then you use the profit that you have from your business to buy a restaurant. So should you keep them under one corporation or two? Now, what happens when now the real estate is taking a little dive and the creditor is coming after you? In the meantime, the restaurant is doing great. Okay, you know, the soto is selling great. Okay, the gado-gado is great. Okay, you're making a lot of profit. Then your creditor files a lawsuit against the real estate business. Well, guess what? Your restaurant business is going to get dragged in. Okay, and people like me, again, are going to want to know about your restaurant business because it's all under one roof. So, best thing to do would be to keep it separate, okay? Also, it confuses the government. Because they don't know how to issue your license. Is it for a real estate business or is it for a restaurant? It also confuses the tax authority because they don't know how to classify your business. Also confuses your customers. So keep it separate. The next side note I have is having a shareholder agreement among the owners. Now, that I think should be done. Okay, I'll do a little discussion. I'll do some discussion on contracts a little later down the road. But having a shareholder agreement establishes a business, financial, and legal relationships among the owners. Okay, it's like a prenup between you and your partners. Okay, the shareholder agreements should specify who invests what, how much, and what percentage. So, for example, one owner brings in the truck, another owner brings in the inventory, and you bring in the money. So you should think about, is it going to be an equal share? Is it going to be more share for you, 50% because you bring in the money? So that's something that has to be spelled out. And next, what percentage of voting rights? So for example, if money is tight and you are a risk taker and you want to open up a second store because you think that may help your financial outlook down the line, then you have your partner who's more conservative. He doesn't want to open up this second store, doesn't want to take that risk, want to make sure that there's money first before you open up the second store. But if you have equal voting rights, equal voting percentage, well, nothing gets done. So think about that before you start making it an equal percentage vote. You should have a majority. Next, the shareholder agreement should specify the title, the role and responsibilities of the officers. So you have the CEO, CFO, marketing director. It should specify each of their duties, authorities, who will do what type of work, who will bring in the business. Got to be spelled out in the agreement. Okay. Then it should also have a paragraph on procedures on how to buy a business, okay, or to sell your business. That has to be spelled out. This next one is something that happens, okay? So what happened when you have this business with your partner and your partner is your greatest partner? You get along fine with him, great, he's smart and everything. But you absolutely hate his wife. Absolutely, you cannot stand her, okay? So when your partner dies and the wife inherits a share, guess what? The next morning, she's gonna show up. She's your new partner. What do you think is gonna happen? Gonna break up real fast, okay? Because you cannot stand her, okay? So you should have an agreement that spells out something like, if one of you dies, the corporation should have the first option of buying that share, okay? Otherwise, then the living partner should be able to have the chance to buy that share. Then if not, then it can be sold to the market, okay? So that should be spelled out. Now, what about a non-compete provision in your shareholder agreement? Think about this, okay? You have your partner, business is not doing too good, and he's thinking that he's in a sinking ship, okay? He's not going to go down with you. So he's going to get out, sell his shares to you, and he's going to open up his own business next door to you. Not good. You don't want that. You want a non-compete clause in your shareholder agreement that strictly prohibit anyone, one of you, to compete against whoever it is in that company.